Honorable Senators, let me give results for this division. Honorable Senators, this was a very tight race. The results as follows: ayes 24, nays 0, abstention 0. The ayes have it.
A bill for an act of parliament to provide for the county boundaries, to provide for a mechanism for the resolution of county boundary disputes, to give effect to Article 188 of the Constitution by providing for the procedure for alteration of county boundaries, to provide for the establishment of an independent county boundaries commission and for connected purposes.
Next order.
Order number 11, the Sugar Bill, National Assembly Bills number 34 of 2022, division.
Let Sergeant Atabs ring the call on bail for 5 minutes. There's some movement. It's procedural because maybe I reduced to 2 minutes.
Well, the senators are still on with the division of the next bill, that is the Sugar Bill, a bill originating from the National Assembly and co-sponsored by the Honorable Senator David Wafula. Remember earlier on, the senators took a vote on the second reading of the County Boundaries Bill, a bill also originating from the Senate. And right now is a 2-minute quorum bell as directed by the Deputy Speaker. Of course, this is to give way for the senators to log out, remove their cards, log out, and then get into the next stage when they will be able to log in and also vote for the second reading of this bill. This is a bill that is at its second reading stage. The debate on this bill also took place exhaustively in the Senate chambers, and right now it is meant to proceed to the next level, but has to go through the normal process of voting for second reading before it proceeds for the third reading. The Sugar Bill is a bill that seeks to provide for the development, regulation and promotion of the sugar industry, to provide for the establishment powers and functions of the Kenya Sugar Board. Well, allow me to hand you over back to the division for this particular bill.
The Sugar Bill, Senate Bills number 34 of 2023, be now read a second time. So, log out, honour members. And in again, we log in and proceed to vote. Okay. Honorable Senators, I want to announce the results of the division. The ayes. Senator Chalege, you don't need to move along learning. You just freeze. You are not a member of this house. Ayes 25, nays 0, abstention 0. So the ayes have it.
A bill for an act of parliament to provide for the development, regulation, and promotion of the sugar industry, to provide for the establishment, powers, and functions of the Kenya Sugar Board, and for connected purposes.
Next order. Okay. Now you can open the doors and withdraw the bus. Next order.
Order number 12, the Conflict of Interest Bill, National Assembly Bills number 12 of 2023, resumption of debate interrupted on Wednesday, 27th March 2024, afternoon sitting.
Senator Chalege Samson, you pro-teach.
Mr. Speaker, thank you very much for allowing us to proceed in debating on this bill. I know yesterday the House was adjourned. Mr. Speaker, I want to say from the onset, I support this bill, the Conflict of Interest Bill 2023. Mr. Speaker, I think it is high time as the fight against corruption must be dealt from the head, a big blow, Mr. Speaker. And you know, many people, some people imagine that you need to be in a public office to be wealthy or to be rich, Mr. Speaker. And the Bible says in Proverbs, I don't know the specific verse, it says the wealth that you have created out of hard work, toil and sweat, your children will inherit. But the ones that you have ill-gotten will be eaten by the moths and rodents and many other funny things, and termites. Thank you, my sister, and termites. And I know Bishop concurs with me with that verse, Proverbs, that says. Mr. Speaker, on the conflict of interest, I agree with the definition because public duty, and we read under on principle. Mr. Speaker, can you kindly protect me from the ladies?
The two Tabidas, I don't know where they are.
Senators, senator ladies,
The two
female
Tabidas.
senators.
The two Tabidas, what is the issue with you?
The two
Tabidas.
And coincidentally, they are smiling around the ML. I don't know, is it because Easter is near or what is happening? Mr. Speaker, proceed by saying that when you look at the leadership and integrity, I will just make 4 points, Mr. Speaker. It talks about conflict of interest. What we are doing is just to enrich, because the architect and design of the Constitution is just to give us the structure. As a parliament, we pass legislation now to ensure, Mr. Speaker, that we enrich. And the fight against corruption can only be won if we have the right legislative intervention in place and policies, Mr. Speaker. One of them is the conflict of interest. We don't want people using their offices to enrich themselves and also give influential, Mr. Speaker. Even this conflict of interest outside the public government offices, even other agencies, Mr. Speaker, where we have sexually transmitted grades in universities and institutions of higher learnings, where we have sexually transmitted job opportunities, Mr. Speaker, and many others, Mr. Speaker. When you go to some of the universities, Mr. Speaker, our young women, girls, and young women and boys are suffering from a disease called, which are perpetuated within the setup of universities and private institutions or learning institutions through sexually transmitted grades, Mr. Speaker. Mr. Speaker, and these are some of the conflict of interest, because somebody who is higher up has undue influence against a person within that organization. So, Mr. Speaker, this conflict of interest, people should not know that they don't need to be in an office to enrich themselves and fairly, Mr. Speaker. Mr. Speaker, on the issue of conflict of interest, I know at the amendment stage I would like proper elaboration, but I know when the jailer committee will table a report, we should also look at their report so that we look at the definition of what is conflict of interest. It should not only look in the public, even somebody who is a chief or Mukasa that was, or a lecturer or a pastor, Mr. Speaker. You know, there was a pastor who was taking a due advantage. That video went viral. And he's saying they were chasing his spirits in some areas that I cannot mention because this is PG. It is parliament-guided event, Mr. Speaker. So, Speaker, on the issue of unexplained asset, this is very important. I know there is well declarations that we normally do as public officers, but we want these issues to be taken seriously. So, Speaker, somebody cannot tell us today that he's worth $1 million, but after staying in an office 2 to 3 years down the line, is a dollar billionaire, Mr. Speaker. As a country, we must take these issues seriously. Every wealth, even if you buy a watch, a car, a property, worth anyhow much, Mr. Speaker, we must tell us as a public official. Because in this country, we are aware of people who are using their offices to enrich themselves, Mr. Speaker. And therefore, Mr. Speaker, we cannot be gerrymandering on the issue of serious on the fight against corruption. So, Speaker, ESCC has been given a function. So, Speaker, I have little faith in ESCC. You know, I've sat in county public accounts. Senator Ledama has sat in public county accounts. A number of my colleagues have sat in county public accounts. We have made many recommendations, Mr. Speaker, for other bodies like ESCC, Mr. Speaker, to do follow-up, to prosecute governors, county officials who continue to leverage our resources, Mr. Speaker. It is very unfair. In fact, I am aware that ESCC might be struggling with capacity, with issues of resource allocation, but they have never shown a proof, Mr. Speaker, to tell us what they have done. The last report when I was the jailer, Mr. Speaker, yours truly in the last issue, the only conviction ESCC had achieved when they tabled the report in that year, and it caused a huge uproar in the floor of the House, was convicting somebody who had taken a bribe of 20,000 shillings somewhere in Eldoret. So, Speaker, the fight of any election can be, not election, sorry. The fight, elections are still very far. The fight against corruption, Mr. Speaker, and larceny and graft and plundering of natural resources will only be won if one or two. I remember there was a gentleman who told us at that time that he was not going for small fish or omenas. He was going for big fish. He ended up nothing on the plate, Mr. Speaker. It is very unfortunate. So the fight against corruption, with this enriching of this bill that has been pondered by Senate Majority Leader Aaron Cheruiyot, is a bill that should be supported by all and sundry so that we fight corruption in this country, Mr. Speaker. And I want to challenge EACC. Most senators here tell us, and even when we work in the villages, I have seen the motion by Senator Ledama Olakina on pending bills. How can pending bills be there when you go to National Treasury, money has been dispersed? It means it has been stolen. So what is EACC doing about it? Nothing. When they are reported, they go and call the governors or anybody who has been accused of corruption and see them you may attend. Mr. Speaker, we are even aware on COB control of budget. And I want them to come clean. Where a county makes a requisition, the controller of budget tells them what we want to do, they give a schedule, then they release money to the county after paying certain percentage. And that is why most of the workers, we are having allegations that some of the controller of budget staff are now owning houses in Karen, Runda, Kileleshwa, because they are colluding, and even Dubai, they are having private summer homes, Mr. Speaker. Mr. Speaker, because they are colluding with county governments to release money that are made under requisition. And the controller of budget, not herself, but some of her officers are going rogue. And that is how governors are misusing and plundering resources. So what is EACC doing about it? Nothing. I saw them releasing a report yesterday saying, I think they say Nyamira is leading in bribery, which county is leading, which ministry is leading in bribery or corruption allegations. But after releasing a report, what next? The EACC has never told the country what they are doing in the fight against corruption. Yet, under the Constitution, they have an obligation to fight corruption in this country. Mr. Speaker, we have many laws in the Fight Economic Crimes Act, Mr. Speaker. We have many laws against fight against corruption. The chicken must come home to roost when EACC will tell us what they are doing in Machakos, in the fight against corruption, in Kitui, in Makueni, in Nandi. And I told you last time, Nandi is the headquarters of corruption. There is a lot of blundering happening here and there, but EACC have done nothing. We have reported a number of occasions, Mr. Speaker. But what the EACC does, they go and smile to the camera with the governors and officials, then they say it's under investigation. Mr. Speaker, And I want to challenge here and DPP, the new DPP and EACC. We must show seriousness, Mr. Speaker. When we go, the other day we have visited a number of counties, Mr. Speaker. I know we'll be visiting Meru soon. When we go there, people will ask here, money has been stolen, so what have you done as a Senate? Our work is to make recommendation. The people who to implement is EACC and DCI. But what are they doing? There is a weak link in the fight against corruption in this republic, and I hope with the conflict of interest bill, Mr. Speaker, it will assist. Then on the powers investigation, I think EACC has enough powers. This EACC is a creation of the Constitution. They are supposed to do their job as per the Constitution. They don't need to get anybody's permission to do their job. What is the perception that people believe that EACC must get orders or phone calls? It is them who, in fact, the fight against corruption, my colleague members, in counties to be precise, will not be won so long as the biggest stumbling block in the fight against corruption is EACC. They have never done something. They can contravene what I've said. They can give us statistics on how many corruption they have found. We remember even in Siaya, under the former county government, where air tickets were being paid for private individuals. No one has been prosecuted in CI. We went to Turkana, the same thing, 100 billion cannot be accounted for. A number of occasions, Mr. Speaker. So as a country, as we pass this, I have mixed feelings. Because we have enough legislation, but there is nothing to show for what we have achieved as a country in the fight against corruption. Mr. Speaker, I agree with, of course, declaration, Standing Order 104, conflict of interest, Mr. Speaker, conflict of avoiding our obligation, Mr. Speaker. The third point is, I wanted is preferential treatment. That is more than obvious. And due influence, that is...
Sorry, I can see there is an intervention, meaning a point of order from Senator Maratian Ezena. What is your point of order, Senator?
Mr. Speaker, I think Senator Cherargei should substantiate the claims that EACC receives phone calls. Thank you.
Senator Cherargei.
Mr. Speaker, I thought as if they are receiving phone call, as if. I'm guided by the answer if it is contrary, because I say as if they are receiving. As if is maybe. I didn't say shall. So I think that is what I meant. Mr. Speaker, and I thank my sister, Mr. Speaker, she's doing a good job. And maybe she wants something in Samburu County in future. Mr. Speaker, on the issue of gifts and other benefits, I think this is a law that was there of economic crimes in 203, you pass. At least you have been around these corridors and you know this law. Where you are given, even as a speaker, if we welcome you, I don't know at which level, when you come to my home and I give you as a friend, I don't know whether you should declare, because I can give you a cow. That is the highest respect in my community we can do. So I don't know whether you'll donate a cow to the Senate or what happens because you are a public official. Those are some of the issues JLAC, through Senator Sigei, will give us a headsway as we progress, Mr. Speaker. Mr. Speaker, on complementary treatment, we are aware there are some organizations, when they need tenders, they sponsor. I remember the issue of tobacco scandal, and may the soul of the late Jacoyo Midiwa rest in peace. And you remember that committee was taken by tobacco to Mombasa for treatment, so that they could pass a law that was impeding the issue of tobacco companies. And I remember the images where members of parliament were swimming along the beaches of Mombasa, and I know Senator Miraj understands what those Mombasa beaches and what happens there. Mr. Speaker, on the issue of contracts with public entities prohibited, I think under open governance, and I want to ask members, when we will be launching a caucus for open governance program, Mr. Speaker, which you sanction OGP, I want to invite members to attend that breakfast meeting on 16 so that they can learn what we mean by what we call beneficial ownership of companies, contributional obligation, and the fight against corruption. Mr. Speaker, you have to note, Senate has taken a lead in having what we call Senate Disc on open governance program. And I know senators who are here understand what OGP means. We are trying to push for accountability, legislative integrity, legislative openness, and Mr. Speaker, contractual obligation and benefit of an ownership being open through open governance program. And I want to thank you, Mr. Speaker, and your office for allowing that caucus to be established. I know these are some of the things we have been pushing in that caucus to ensure that we have what we call obligations, Mr. Speaker. Most where corruption happens, Mr. Speaker, is during procurement processes. I think that's where corruption starts from. I remember there was a CS, not a CS, an ambassador of America, I don't know his name, I forgot. He said Kenya loses around 700 billion through budgeted corruption. I don't know, it was around 2020, I think an ambassador of US, he made it in media. Mr. Speaker, we need to be careful, and I remember when we were looking through budgetary process and many others, so that we look at it, procurement is where issues happen, Mr. Speaker. In conflict of recruitment, I know whenever KDF and other people are recruiting, Mr. Speaker, we hear parents complaining that they are paid 300,000, 200. You have seen even here in Eldoret, RTS training school, here in Eldoret. You normally see before reporting of the recruits, you see a number of young people being taken to court because they have fake recruitment, KDF recruitment letters. I'm happy it has been captured to protect our people who, Mr. Speaker, they unknowingly give out 100,000. I know the Bribery Act says punish the briber and the bribee. Punish the bribing, the briber and the bribee, Mr. Speaker. I know that's what the Bribery Act is. The one who gives out and the one receives. The bribe, Mr. Speaker, the English there is a bit problem, but I know members understand what I mean. It is the one who receives and who one takes, the law punishes them equally. Mr. Speaker, on the conflict, Mr. Speaker, on the conflict of interest and the recruitment, Mr. Speaker, finally, Mr. Speaker, allow me to say this in support of this conflict of interest bill. Mr. Speaker, government officers should be aware that part of the work we do is to openly, and the courts have ruled, Mr. Speaker, any public officer is subject to open criticism and constructive criticism, Mr. Speaker. Mr. Speaker, you are aware I'm in court for only representing my people and speaking out and raising serious issues, Mr. Speaker. The law has ruled, and senior counsel like Danson Mahanzo will agree with me, and even our junior learned friends, Senator Rafael Chimera, will agree, Mr. Speaker, that any public official does not have limitation, Mr. Speaker, in terms of criticism. So I find it odd and weird that if Senator Cherargei can be sued for speaking about roads.
From Senator Chimera.
Make it quick.
Speaker, I rise under Standing Order 105, Mr. Speaker. I rise under Standing Order 105, Mr. Speaker. Is Senator Fonandi, Senator Cherargei, factual by stating that I'm his junior in practice, Mr. Speaker? He was admitted the other day, I think in 2020, Mr. Speaker. I have practiced law for over 6 years, Mr. Speaker, so he's actually my junior, Mr. Speaker, and not what he's trying to say, Mr. Speaker. Whatever he's saying is misleading the House, Mr. Speaker. Can he clarify, Mr. Speaker? I'm actually a senior in practice. And withdraw and apologize, Mr. Speaker.
Maybe I request both of you to bring your certificates of admission so that I can make the determination. But if you,
Mr. Speaker,
if I use my eyes physically, you look junior to him, but maybe not academically.
Mr. Speaker, I can't get factual. So on the statement of Act 105, since I don't know when he was admitted, allow me to withdraw that part called junior and call him my learned friend. Mr. Speaker, but you don't need to question Justice and Legal Affairs Chairman Emeritus, Mr. Speaker, because by the fact that I'm the Chair Emeritus of JLAC, that surpasses anything else, Mr. Speaker. It means I have seen a lot in the practice, and I'm senior. In fact, under LSK, I should have been given senior counsel by the virtue of being a JLAC Emeritus Chair when this country was undergoing a lot of challenges, including the issue of BBI. And we stood tall, Mr. Speaker. Finally, Mr. Speaker, in support of this conflict of interest, let any public officer know that you cannot sue a member of parliament for representing his people. Personally, my suit in court is because I spoke about the roads in Nandi, Mr. Speaker. And we will not be intimidated and blackmailed by pedestrian civil suits against me, Mr. Speaker. I will always stand to represent. The other day, we were discussing about Meru. The other day we were discussing about all other counties, Mr. Speaker, because our business is to represent. Mr. Speaker, the moment you gag members of parliament, then we don't have necessity to be elected. Because one of the law of a member of Senate is to do representation oversight, and I'm doing my oversight. I know that suit, Mr. Speaker, is trying to intimidate and cow me not to oversight the work people are doing. But we are going to come back better, bigger, and with a bang, Mr. Speaker. I want to assure you, take my word, Mr. Speaker. With those very many remarks, I beg to support this bill and see the fruition, Mr. Speaker. Thank you very much.
You send, I take your one to the bank. Okay, before we proceed with the debate on this bill, I want to give the chair, the chair, Justice and Legal Affairs Committee, to table the report on this bill, so that senators interested can also produce the report from the JLI committee. Chair.
Thank you very much, Mr. Speaker. Mr. Speaker, I beg to lay the following paper on the table of the Senate. That is the report of the Conflict of Interest Bill 2023, National Assembly Bills number 12 of 2023. Honorable Speaker, the Conflict of Interest Bill, National Assembly...
Chair, I'll give you that opportunity to give your contribution. Let's get the other paper from Chair Finance and Budget. Lay the paper and proceed and give notice of the motion.
Mr. Speaker, sir, I beg to lay the following paper on the table of the Senate today, the 28th of March 2024. It's a report of the Standing Committee of Finance and Budget on the status of implementation of projects funded by the conditional grant of construction of county headquarters.
Give notice of the motion.
Mr. Speaker, sir, I beg to give notice of the following motion, that the Senate adopts the report of Standing Committee on Finance and Budget on the status of implementation of projects funded by conditional grant for the construction of county headquarters laid on the table of this Senate today, Thursday, the 28th of March, 2024. Thank you.
Chair Jailak, now you spend your minutes to contribute.
Like Chair should take a seat. Speaker, you know, some of us are stickler to conventions. I'll be a bit lost. Personally, I'm a bit lost, Speaker. I need your guidance on this. We were on the order where we were debating the conflict of interest bill. In between the Speaker, you have allowed JLAC to table a report on the same. But there was also Senator Mandela, chair of Finance, who also laid a paper and gave a notice of motion. Where are we in the order paper, Mr. Speaker? I'm a bit lost. Because I'm trying to prepare to contribute to...
Now, that is the discretion of the Speaker. I give Senator the Chair Finance just reorganized what we are doing this afternoon, just to give them the opportunity to table the paper, to read the paper and to give notice. Then now we are back to order number 12. Chair Jailak, proceed.
Thank you, Honorable Speaker. I believe the Honorable Senator Wambua will get an opportunity to contribute to the conflict of interest bill. I hope the intervention was because of his interest to contribute to this particular bill. And since we have tabled a report, I will wait for his comments on it. But then again, Honorable Speaker, thank you for giving me the opportunity to contribute to this bill. And before I do it, Mr. Speaker, I would like to appreciate the membership of JLAC committee that sat to deliberate on the bill the moment it was commissioned before the committee. We received quite a number of comments from stakeholders. In this case, to be very specific, Mr. Speaker, we received over 13 memoranda from Service Commission, County Assembly Fora, Kenya Civil Servants Association, the Kenya Law Reform Commission, among others. As I said, we received up to 13 memoranda from various interested stakeholders. And Mr. Speaker, as JLAC, we did concur with the majority of the stakeholders, particularly on one aspect that observed that while the bill seeks to repeal the Public Officers and Ethics Act 2003, it doesn't adequately speak to and provide for fundamental aspects of the ethics spelled out in the Public Officers Ethics Act 2003. The proposed amendments, therefore, to this bill and by this report is a product of very extensive deliberations and consultations that have taken place to ensure that we have a good law in place that will stand the test of time. Honorable Speaker, I wish to thank your office and the office of the clerk for the logistical and technical support that was accorded to this committee during the extensive consideration of the bill. I equally wish to thank the stakeholders for their submissions and comments that greatly enriched our consideration of the bill. And finally, I want to express, as the chairperson of JLAC, my sincere gratitude and appreciation to the honorable senators of the committee and the members of the Secretariat who made useful contributions towards the preparation and production of the proposed amendments, which I will briefly, Honorable Speaker, run the House through. On behalf of the Departmental Committee of Justice, Legal Affairs and Human Rights, and pursuant to the Senate Standing Orders 148, the committee, Mr. Speaker, proposes the following amendments to the bill. As I stated, Honorable Speaker, we received over 13 submissions from various stakeholders. And upon consideration, the committee made several proposals to amend the provisions of the bill. And the first one, Honorable Speaker, is a proposal with regards to the provisions of Clause 3. Clause 3, Mr. Speaker, speaks to the objects of the bill. And the committee proposes that Clause 3 be amended by introducing, refreshing the bill. Instead of it reading enhance integrity of public office and public confidence in the delivery of public service, the committee proposes that subclause 3C be amended to read as follows: enhance public confidence in the integrity of public office and delivery of public justice. Mr. Speaker, the reason behind this proposition is because of the content of the stakeholders' report with regards to there are personal conflict of interest which are limited to the individual and those that can come out by virtue of the office that a public officer holds. Mr. Speaker, secondly, the committee proposes an amendment to Clause 13. Clause 13 of the bill, Mr. Speaker, we as a committee are proposing that we become very specific to private interest of the officer. In this case, we are borrowing it from the stakeholders' submission to the effect that besides the office, we should ensure that the bill speaks to private interest of the officer. Therefore, Clause 13 is proposed to read that a public officer shall not directly or indirectly use or allow any person under the officer's authority to use any information that is obtained in the course of performing official duties and is not available to the public to improperly further or seek to further the private personal interest of the officer. This particular recommendation is to ensure that we deal with the person who has authority in either the entity or the authority that is authorized to check on the conflict of interest arising by virtue of the office. The committee further proposes an amendment to Clause 15. Clause 15 speaks about a requirement on the person of the public officer to disclose when such a person has accepted to perform certain functions. And I would like to read for the benefit of the members that a public officer shall not allow himself to be influenced in the exercise of an official power or performance of a duty or function by plans for or any offer of outside employment. And the very specific subclause which we are proposing an amendment is a requirement of the public officer to disclose in writing to the reporting authority any offer outside of employment. Mr. Speaker, the committee arrived at a proposal to amend the requirement to disclose an offer and instead to disclose acceptance, because it does not become an impediment to your judgment before you accept an offer, such that making reference to offer in itself will be misleading, because as long as you have not accepted any offer, it does not in any way impair on your judgment, it does not impair on your character and personality, but the moment you accept that, that is when it comes in to become a conflict on the part of the public officer. Further, the committee proposes amendment to Clause 19. Clause 19 of the bill speaks to a requirement on the part of public officers on contracts with public entities which are prohibited by virtue of an officer holding a certain public office. And the committee proposes that instead of a public officer being denied or being referred to as a beneficiary, this is going beyond, I would call this, the committee made reference to it being over legislation. And we have proposed that Clause 19 be amended by deleting the reference to a public officer being denied to be a beneficiary of. And therefore, section will only read that you as a public officer should not, at any given time, as long as you are holding a public office, you should not be a party to any contract that will directly affect the performance of your role as a public officer holding that particular office. We have equally proposed an amendment to Clause 27. Clause 27 of the bill, Mr. Speaker, is making reference to the fact that a former public officer, in this case, if you have been holding an office in this, a public office, and you have quit that office, you are required to be not in a position to do certain things. And in this case, provisions of Clause 27 prohibits you as a public officer from holding certain office or from performing certain roles of that particular office. And Clause 27 prohibits a public or a former public officer from engaging with that office for a period of 2 years after exiting the office. And in this case, there is a specific reference to state. The committee is proposing that instead of making reference to it being you being prohibited from dealing with the state, it is too wide that it covers almost every other aspect of public office that an individual can deal with. And the committee proposes that instead of making reference to a state, we make reference to an authorized entity that in this case is a reporting entity, which has been described at Section 2 to mean certain state entities or state organs with authority to deal with service delivery to the public. The committee further make reference to Clause 29. Clause 29 is now where there is a specific reference to a prohibition of a public officer from being engaged to represent an entity that he or she previously worked for a period of 2 years. There are qualifications to that particular section. Section says you can only be allowed to immediately upon termination of your engagement with the public office after 2 years. You can only do so if and when you have sought for exemption and you have met certain qualifications, one of which, Mr. Speaker, includes the fact that you are able to explain that you are not directly involved in decision-making in the previous entity that you are working for. Secondly, you had no access to important policy information in the reporting entity that was your former employer. And lastly, you are expected to show that you did not possess, or rather you do possess expertise such that your expertise is required to be utilized in the performance of certain decisions in the entity that is seeking to support you. In this case, if you want to be exempted, you are required under the provisions of Section 29 to make an application in writing so that the commission or the entity can exempt you in writing. This particular section, Mr. Speaker, has also given a protection to that application so that the entity does not take forever to respond. And it has given under the provisions of 29(2) that that request must be responded to within 30 days. So a decision as to whether or not you can be allowed to represent must be made available to you within 30 days. The committee, Mr. Speaker, has taken cognizance of the fact that these preconditions does not and should not apply to persons who are in their professional capacity, could be engaged courtesy of the provisions of the Constitution that entitles an entity or an individual to get services from such individuals. And the committee has proposed an introduction of subclause 3, which says that the provisions of Section 27 and 28 shall not apply to a former public officer representing another person in any proceedings before a court of law or tribunal established by law, including a witness. Why did the committee, Mr. Speaker, seek to propose such an introduction of a subclause? 3 reasons. 1, we would, in most cases, be required to have expert witnesses who, by virtue of their previous office, they have knowledge of an information that an entity is seeking to establish. That is one of the reasons why the committee sought to introduce this additional clause, so that we don't lose on investigations by virtue of the fact that since you were a former employee, the law bars you from participating in an investigation that requires your expertise as a witness. Secondly, of course, is protection of representation of clients in courts of law or tribunals where a professional, in this case like a lawyer, who by virtue of the constitutional edict, a client is entitled to pick a person of his choice. And that is why, as a committee, we've proposed to introduce that particular sub-clause. Mr. Speaker, the committee has further introduced under clause 29, the committee, has confirmed that the time limitation provided to the commission or the authorized entity to respond to an inquiry as to exemption should be 30 days. Why? It is because we live in Kenya, Mr. Speaker. An entity that would, for whatever reason, is malicious of authorizing a representation can take forever. The way we talk about investigations taking ages to conclude when an individual has, for example, been suspended to, and that is something that is coming in the subsequent proposals we've made as a committee, but the committee felt that it is important to make sure that within a period of 30 days, if one has sought to be exempted, that exemption should be done in writing within a period of 30 days. Mr. Speaker, the next clause that the committee dealt with is the provision under Clause 34 of this bill. Clause 34 of the bill talks about access to declaration. This being a conflict of interest bill, the law is proposing that as public officers, we are expected to make certain declarations in certain intervals to the public and for purposes of making sure that we are protected as public officers. And for this reason, Section 34 provides that you are required to avail the declarations upon application to either the commission or to the entity that is a reporting entity. And in this case, the committee has proposed that Clause 34 of the bill be amended to ensure that the rights of individuals in terms of the constitutional provision on the rights of privacy, and also where we are seeking to comply with certain court orders, are monitored so that entities do not abuse this particular provision. And we have proposed, therefore, that we can only be under an obligation to disclose such information where the Act under subclause 2 had made reference to due process. Due process is very wide. The committee says, what is due process and how do we protect private individuals and confidential information from being abused? Because an entity can decide to say, we have conducted investigations internally and have made recommendations, probably as a committee or as a team in charge of investigation, to force or compel production of certain confidential information. The committee has proposed that in order to protect the public, in order to protect officers who have been subjected to either disciplinary process or an investigation process, due process cannot and should not be left as wide as it were, but we have sought to say this due process can only be due process which is subjected to the right to privacy as provided for under the Constitution and pursuant to a court order or the Access to Information Act. That way, we will be protecting privacy, we will be protecting the compliance by institutions with the law, and we will, by extension, ensure that there is no abuse of the right that is provided for in law by this particular law to ask for and compel individuals to avail or to avail information. Mr. Speaker, I notice my time is running up. Clause 41 is another clause that the committee has also sought to. This one is suspension from office. The clause under 41 says that subject to the Constitution and any written law, a public officer may be suspended from office with full pay pending the investigation and determination of allegations made against that officer where such suspension is considered necessary. Mr. Speaker, the provision that grants the commission an entitlement or an entity an entitlement to suspend someone is open to a lot of abuse, especially in terms of the timelines within which you can be asked to be away from office pending investigations. And as I earlier on alluded, institutions can take more than 3 months, more than even 1 year. We are aware of certain investigations that have been conducted for over the last 5 years, where in any inquiry, you get an excuse that we are still conducting investigations. The committee therefore proposes that clause 41(2), which requires or which mandates an entity to release an individual on suspension for a period of 90 days, proposes that that should only be the maximum time. And we say that if therefore these investigations cannot be timely, such an individual cannot be out there for more than 90 days, even if the investigations are not concluded. And we have therefore proposed that if the commission or a reporting entity fails to conclude the investigation within 90 days, the investigation shall be deemed to have been concluded at the expiry of the 90 days, and the officer shall resume his or her office. The reason why we are proposing this, Mr. Speaker, is to ensure that investigative entities, whether it is DCI, EACC, or an entity that is a reporting entity, does their investigations within certain timelines, and also it guards against witch hunt. This is one of those propositions where if you leave it open-ended, there will be a lot of abuse of this particular clause, because what will happen, institutions will never bring to a closure investigations. And if it's just a mere allegation, this is something that where the law has given you specific timelines, you'll be compelled by that law to make sure that you conclude. And if there is no case, definitely allow the person back to office. If there is a case, then charge the individual, because the moment that person is charged, then there is a requirement in law that you are then under suspension because you've been charged before a competent court of law and you are on half salary for a certain period. In fact, the Anti-Corruption and Economic Crimes Act, Section 62, I believe, provides that such person, once charged, is on half pay, and the case should and ought to be concluded within a period of 24 months. That has been a subject of litigation, Mr. Speaker, and that informed this committee to say we limit the timeline within which investigations are to be conducted, and if that does not happen, then it is deemed to have been concluded, and therefore the person is entitled to report back to office. Lastly, Mr. Speaker, the provisions of Clause 42. This is on recommendations of the Commission. In this case, the Commission we are making reference to is the Ethics and Anti-Corruption Commission. The committee proposes that since it is this particular act will not only be implemented by EACC, there are certain other reporting entities. We should also, under the provisions of that clause, include the reporting entities so that besides the Commission, we have got these other reporting entities or authorities who can be able to make sure that they propose and receive reports for purposes of ensuring that there is an implementation. Mr. Speaker, I wish to urge, I listened yesterday when the majority leader was moving this particular bill. This is one of the reasons as to why I would like from this particular point to urge the members to push for the passage of this particular bill. It will help not only in fighting the corruption, which has been cutting across, but instead it will help us to make sure that this cancer that we talk about from morning to evening in each and every institution, whether it's private, whether it's public, members of this committee are proposing and asking that this House should be the House that will support in making sure that this bill is passed. I am aware that in the year 2019, the first publication of this bill was done, but it has never come before the floor of the House. Now that the National Assembly has passed, and now that we have received it in this House, I urge the honorable members to support this bill. I urge them to read the report, read the comments we have received from the stakeholders, and support the bill so that we pass it on. Mr. Speaker, I am actually concluding by saying that the bill, though it is repealing certain provisions of some acts, like in this case, the Leadership and Integrity Act, Ethics and Anti-Corruption Commission Act, Anti-Corruption and Economic Crime Act, it is amending certain provisions for good cause. The repeal of the Public Officer Ethics Act, which is what we made comments as a committee in the first instance, is also one of the ways to make sure that once this bill is enacted, we will be having a legal framework that is able to fight the corruption across the country and to make sure that service to the public is made within the confines of the expectations of every individual, including the persons who are serving in such public office. Mr. Speaker, I support the bill, and I thank you for giving me the opportunity to support the bill. Thank you.
Thank you, Committee Chair. Senator Wambua Enoch.
I thank you, Mr. Speaker. I'm not sure what Senator Manzo is saying, but Mr. Speaker, I want to make my comments on this bill, the Conflict of Interest Bill, Bill number 2023 of the National Assembly, without necessarily committing myself at this point as whether I am in support or I am opposed to it. For the simple reason, Mr. Speaker, that the Jailer Committee has just tabled their report. We will take time, Mr. Speaker, to go through it, and by the time we get to that reading, then it will be clear whether this bill merits our support or it doesn't. Mr. Speaker, I will say a few things about the bill. First of all, Mr. Speaker, the bill begins by creating an obligation on an independent commission. A commission established by an act of parliament, the Ethics and Anti-Corruption Commission Act of 2011, a commission that is deeply rooted on the Supreme Law, Article 6, on Chapter 6, on integrity. And so, Mr. Speaker, then the first question that I ask myself, this bill, is now that the bill creates an obligation for a commission that is established by an act of parliament, what would have been easier? Perhaps to amend the EACC Act and load matters to do with conflict of interest, or to come up with an independent act to deal with conflicts of interest. Mr. Speaker, I will look at the report of the committee to establish whether they have created a nexus between the Ethics and Anti-Corruption Commission Act of 2011 and the proposed law. Because in the absence of that nexus, then we run the risk of creating confusion by getting one law to create an obligation for another set of laws. The Speaker, yesterday, I followed the release of the bribery index by the EACC. I saw the chairman, my bishop, Bishop Dr. David Oginde, at pains, declaring that, Mr. Speaker, Kenyans are bribing more, and actually that cost of bribery has also almost doubled. I saw him at pains saying that if we don't tame bribery, then corruption is going to kill us as a country. The Speaker, those words coming from a bishop as respected as Bishop Oginde must begin to ring a bell in the minds of all public officers and every Kenyan, because when we listen to him, Mr. Speaker, I also heard him prescribe a very easy way out of this corruption problem. And he said, it's very simple. Don't ask, don't give, and don't take. If we were to then follow that prescription, perhaps we would live in a better country. The Speaker, Part 3 of this bill, Clause 10, makes reference to decision-making or people in positions of decision-making in elaborating what conflict of interest means. And I want to read that clause because, to me, it's a very important clause, Mr. Speaker. And it says, Clause 10, 1A, a public officer shall not make a decision or participate in making a decision relating to the exercise of an official power or the performance of a duty or function if the public officer knows that in the making of the decision, the officer would be in conflict of interest. The Speaker, I have read this clause with more than passing interest. Because, the Speaker, we have just passed a law on affordable housing. And if this law had been enacted before passing the affordable housing law, then perhaps the question that we should be asking ourselves would be, the persons holding public office who have been at the center of decision-making in the affordable housing law, are they conflicted or are they not conflicted? Mr. Speaker, I want to extend that thinking a little further and ask myself, a public officer working, say, in the Ministry of Interior or any ministry, who is an expert on national security and is paid by the government of Kenya. The Speaker, is that public officer conflicted if and when, during his free time, he gives lectures in a university to equip young people with matters national security? Is that public officer conflicted? I ask myself the second question, Mr. Speaker. A medical doctor who is an expert in maybe is an expert in maybe dental health, and he is paid by the government of Kenya in a public hospital. Under this new proposed bill, and through the jailer committee, are we making the conclusion that that medical doctor, in his free time, will be conflicted if he were to be found offering dental care in a private clinic or in a personal clinic? And lastly, Mr. Speaker, a mechanical engineer working, say, in the Ministry of Trade, and during their free time, they have established a garage for their son or their nephews, their cousins, their relatives, their friends. Are they conflicted? Mr. Speaker, this matter of conflict of interest is such an important matter that perhaps, and I said I would take time to look at the report by the jailer committee, perhaps we need to ask ourselves, to what extent do we go in defining conflict of interest? Or is it even possible to define conflict of interest in a law? Mr. Speaker, I say those things because I remember and I'm guided by our own standing orders, standing order number 104 of the Senate, and it mandates and obligates a senator who wants to make a comment or debate on a matter of which they have a pecuniary or proprietary interest to first declare that interest. The Speaker, guided by that, is then a declaration of interest, is a public declaration of interest or a declaration of interest in writing, is it a cure to the consequences of the conflict? So that then in that case, if I am a medic serving in a public hospital and I make a declaration in writing that I am also involved in a private clinic, is that writing enough to cure the consequences of the conflict? Mr. Speaker, I want to conclude by saying that, Mr. Speaker, the provisions of Clause 7, and I want to see what the committee has said on the provisions of Clause 7 of the proposed law, that the Commission now can act suo motu on its own motion to go and investigate conflict of interest. The Speaker, we live in this country, and we know, and I'm not saying this is going to happen, but we know, the Speaker, that commissions that are supposed to be independent in discharge of public service, more than once, have been used by those in authority as weapons to harass and torment people who hold a different view, especially a political view. Mr. Speaker, I'm just saying this and cautioning that perhaps if this law will pass, the law must not be the reason why the ESCC, and I've heard you say, Mr. Speaker, that JLAC is proposing bringing on board other entities and agencies that will implement the provisions of this law. I'm just praying and hoping that, Mr. Speaker, that when this bill becomes law, if it becomes law, then it will not be creating an excuse for either the EACC or any other public entity under the control of the current government or future governments to harass people who political parties. We don't legislate for our coalitions. We legislate for this country and we legislate for posterity. I'm just hoping that after going through the report of the JLAC, then we shall be properly guided and then a decision will be made as to whether then to support or to oppose this bill. Mr. Speaker, with those remarks, I submit.
Senator Manzo Daniel Gitonga.
Thank you, Mr. Speaker, for giving me an opportunity to contribute on this very, very important law. Mr. Speaker, the biggest problem in Kenya and many other African countries and many other countries in many parts of the world is corruption. This law on the conflict of interest of any member of the community or Kenya or any part of the world in regard to that particular regime goes a big way to save the resources of the country and the resources of the people. Mr. Speaker, corruption has brought down a lot of countries, and especially official corruption within government status. And the conflict of interest, which may not be properly or captured or defined in this particular law. This law having been to the National Assembly, and now having been forwarded to the Senate. And I want to thank the committee of JLAC in the Senate for going further to come up with amendments to make the law stronger, other than the usual practice we do of getting laws forwarded from the National Assembly, then we rubber stamp them and we forward them to the executive for signature. So this particular one, there has been an extra effort. And when you look at the definition of conflict of interest, meaning a conflict between the public duty and private interest of a public official, in which the public official has private capacity interests that could improperly influence the performance of his official duties and responsibilities. One of the areas this law is highly applied is in the judiciary, Mr. Speaker. A lot of judges have been very honest when parties come before them to say that one of the parties to the suit is personally known to me, so they declare the interest, or was my classmate, or for those reasons I'm likely to be biased, and therefore they recuse themselves from presiding over the matter. And what follows thereafter, Mr. Speaker, is the file is transferred to another judge who probably does not know all the parties at all and is able to adjudicate. But, Mr. Speaker, how many times judges are that honest, Mr. Speaker, or any judicial officer, or any officers performing quasi-judicial functions? And this goes even to arbitrations and many other organizations of the government. One of the affected acts, because there are several acts of parliament, Mr. Speaker, which have been affected by this law. And it's going to touch on quite a number of other laws. And Mr. Speaker, there's something called conflict of laws. How conflicting is it, Mr. Speaker? We have the Official Secrets Act. Mr. Speaker, what do you do to a person who has been a minister for interior. And there's a lot of secrets of the nation. There are quite a number of things which are handled privately or secretly on the benefit of the nation, especially security, information. The generals in the army, people dealing with the security, external security of the country, people dealing with the internal security of a country, people with information, when leaked, can be used by our enemies to create mayhem or cause harm to the nation. So therefore, Mr. Speaker, those people holding those positions have information with them, which, if conflicted, Mr. Speaker, can result into a lot of damage of the country. And therefore, the declaration of interest is important. It begins with this House from our standing orders and goes on to other parts of public officers. And a lot of it, Mr. Speaker, is when the public officer has to gain. Now it comes to the commission, the implementing commission, meaning the Ethics and Anti-Corruption Commission established under Section 3 of the Ethics and Anti-Corruption Commission Act of 2011. Mr. Speaker, ESCC is one of the very, very key elements, one of the major institutions, and I'm happy with what the chairman of ESCC did yesterday to release the corruption indexes in the country, the ministries, where a lot of money is being lost. Mr. Speaker, earlier on there were reports that billions of shillings get lost every day, Mr. Speaker, through corruption. And that means the people of Kenya are losing a lot of their taxes to individuals' pockets, whereby instead of the nation prospering, individuals prosper, Mr. Speaker. In this regard, Mr. Speaker, this law is very, very important. And as I've said, I like the fact that Senate, under your leadership in JLAC, has taken the matter very seriously, have consulted some of the stakeholders in this, and mainly one of the major stakeholders is the Law Society of Kenya, and many other organizations and individuals, Mr. Speaker, who have an interest in having a better nation. But how do we deal with corruption, conflict of interest, when ESCC is not strengthened enough to deal with corruption in the counties, of which now counties, from the information we have, are likely to face extinction, and we are here to protect devolution. If, when you go by the latest judgment, Mr. Speaker, say that some parts of Government Proceedings Act are unconstitutional, and therefore now anyone can auction government. It means then counties, from the debts they have, can be auctioned to the last coin. And therefore, it affects devolution in a certain way. But again also, some of the counties have been very difficult. Some conflicted officers in the counties have refused intentionally to pay bills to people who have worked for the counties. People who have done work for the government, then the government simply just refuses to pay for years. And you force that person to go on their knees or to close down their businesses and to close down their livelihoods, Mr. Speaker. So this law will go into a long, long way to make sure that most of these things are taken care of. But more important is, if you have found to have been conflicted and you are doing business with the government, or your companies are the ones which are associated with the procurement and are procuring, they're procuring, business from government, and you happen to be there and you're just a broker. Are we giving business to the right people in this country? Is it just cartels, or just making sure that certain individuals are the ones who benefit? Even when people go for tendering, the tendering is just, a cosmetic affair. Whoever will win the business is known. And the same thing applies when you are doing recruitment. for prison officers, KWS warders, the army. In fact, it is rumored that for one to go to the army is so difficult. Although they announce there's no corruption and the individuals who are good are going to qualify to go to the army, the moment you go, you participate in the recruitment, you are very fit, you are qualified, including the health requirements. But somehow, even in the running, if you are number one, you never end up in the army, unless some of the retired generals recommend from different regions of the country. Really, that could be good for further security, or if security scrutiny is done, because if the wrong elements are in the army, then you have a lot of secrets leaking out. But how do we make sure that there is no conflict of interest, that certain people are not just marioneting the whole exercise and making sure everybody is playing as they wish? And how do you make it equal for every individual so that a poor person who has no influence through whatever means can make it to the army or to all those agencies, including the prisons, fairly and without paying a bribe through agents who are conflicted? And that it has become like a common practice that every Kenyan knows before you are conflicted, there must be corruption. Sometimes they use big names, that unless your name comes from State House, for example, you cannot be recruited in the army. Unless your name comes from the MP, you cannot be recruited from the army. Unless your name comes from the senator, governor, then what's the use of holding a recruitment exercise if all that is a wastage of the people's time, and you will finally just recruit as you please? So these are some of the things this law wants to check, to provide equity in the country, to make sure that each young person in this country, whether rich or poor, has an equal opportunity as the other. How do you kill this corruption? One of the ways of killing corruption, and I really want now to say that it's a high time we amended the Constitution to bring back the death sentence, Mr. Speaker. Just like jurisdiction like China, if you are found participating in corruption, you actually cause the death of other people, and therefore you should also be sentenced to death. It will create sufficient fear that if you are stealing from your own country, you are stealing from the others. If you are disadvantaging the others so that they cannot live, then why should you live, Mr. Speaker? I think it's a high time, when considering the amendment of the Constitution, we brought death sentence back, and especially in matters related to corruption. And whoever is conflicted, Mr. Speaker, and finds that they have stolen resources from the nation, then we must have a proper recovery mechanism, so that just as the verse in the Proverbs say, that whoever works hard then leaves wealth for their generations. But whoever steals then loses everything, so that people will stop the practice of shortcuts and stealing. You know, people who have worked hard, did savings, paid taxes, and when the taxes are put together, they are just stolen by a few individuals from certain regions of the country, and the rest of the country continues to be poor, Mr. Speaker. So we really want to make sure that this law goes through, and the punishments given under 43, under Article 43, if you go to 43 under the miscellaneous provisions, Mr. Speaker, you find that a person who contravenes any provisions of this Act for which no penalty is provided shall upon conviction be liable to, if the person is a natural person, a fine not exceeding 4 million shillings, or to a term of imprisonment not exceeding 10 years, or to both. And then it goes on, if the person is a body corporate, like a ministry or a state corporation, a fine not exceeding 10 million shillings. In addition to the penalty under subsection 1, the person shall be liable to a further mandatory fine if, as a result of the conflict that constituted the offense, the person receives qualifiable benefit, or any other person suffered a quantifiable loss. Mr. Speaker, I believe that the most important thing is to recover back what this particular person has stolen. That has not come out fundamentally in this law. Although we have laws dealing with recovery and all those things, they have also been choked by corrupt practices and conflicted practices. And in the same breath, Kenyans have found it very, very difficult to get themselves out of this, and we continue to lose as a country. The only way we are going to do the affordable housing is to first kill corruption in the country. The only way we are going to do our roads networks to heavily village tarmacked is doing away with the corruption in the Ministry of Roads. The only way we are going to make sure that we provide every Kenyan with water to every home and to every farm for irrigation is first by dealing away with corruption. The moment we don't deal with corruption, Mr. Speaker, it will be a waste of time. The moment we don't deal with conflicted civil servants, it is a waste of time. And the moment this particular law does not get implemented, it is a waste of time. Kenyans need even to go back to history. We need to go back to our morals. Many countries which are successful survive on morals, so that children know it is wrong to conduct corruption. It is wrong to receive bribes. It is wrong to give a bribe. From primary school, then it goes to secondary school, then to university, then through the churches, then through NGOs, and through a general culture of a country, of the general goodness of a nation, but not the individual benefit. Then, Mr. Speaker, we'll be beginning to build a nation. And in my own thinking, Mr. Speaker, I think that will take a generation or two before we could achieve such a country. I thank you, Mr. Speaker. I support and I look forward to third reading, where we can bring in amendments and make the law stronger and strict, and that will achieve the purpose it is intended for, so that it doesn't become just like Chapter 6 in the Constitution, which is just there. It's supposed to be implemented with such law. Just like the Anti-Corruption and Ethics Act, which is just there, with no resources to implement. Just like many other laws we have, and we hardly implement them for lack of goodwill generally of the nation. I thank you, Mr. Speaker. I support.
Thank you, Senator Manzo. Senator Karungu Dhangwa.
Thank you very much, Mr. Speaker, for this opportunity to also weigh in on this issue of conflict of interest bill. And as I do that, Mr. Speaker, it's also good to say that in today's order paper, I can also see my bill on public holidays is scheduled to be debated. I also would want to take this opportunity, maybe we can discuss it after the holidays, because, you know, tomorrow is Good Friday. We have a Saturday and Sunday in between, and again, Monday is a holiday. So I would want Kenyans to take these 4 holidays and see what they can do with it. Then from there, we'll be able to get to know whether my holiday bill is still viable. Mr. Speaker, the issue of conflict of interest, as much as I wouldn't want to say whether I'm in support of this or not support, or probably I'll bring amendments or not, I think in our culture, in our society, in our country, I think conflict of interest is immeasurable, Mr. Speaker. I think we should have come up with a bill that has indicators, that we have to mention them by name, we have to mention them by word, that if you do this, you'll have broken the law, Mr. Speaker. Because if we leave it like that, just everybody needs to declare a conflict of interest on a certain matter, Mr. Speaker, what would you call these examples that I want to give you? Mr. Speaker, when we talk about bias in your work as a public officer, that is conflict of interest. Personal relationship, that is conflict of interest. Self-dealing, that is conflict of interest. Preparation when it comes to treating somebody as a friend, that is that is conflict of interest, Mr. Speaker. Mr. Speaker, in this House, we have conducted a few impeachment hearings. I want to give you an example of Meru impeachment, whereby a deputy governor was a witness and he wanted his governor to be impeached. Mr. Speaker, would you call that conflict of interest? Because he was the next beneficiary if that impeachment occurred. He's the person who could have gotten that seat, Mr. Speaker. So does that mean that is conflict of interest, or does that mean he was exercising his mandate to make sure that the county of Meru get rid of the governor as per the allegations that were there then, Mr. Speaker? Mr. Speaker, in the Kisii impeachment of the deputy governor that we just did the other day, Mr. Speaker, we saw a father and a son giving their accusation and testimonies on the floor of this House against one another, because one was a friend of the governor, the deputy governor, and the other one was conned by the said person, as per the allegations that were there, Mr. Speaker. Would you say that is also conflict of interest? I think this bill, as I said, should come out clearer, Mr. Speaker. If you look at the definitions, what is a private interest? It says it means a personal benefit, privilege, exemption or advantage that a public officer or a person affiliated to a public officer may gain from the office that the public officer holds, and which may influence the judgment of a public officer in the exercise of the public duty, but does not include interest in decision or matter to that. Mr. Speaker, I believe a deputy governor who would benefit from such a seat when a governor is removed from office, from this definition, I think that will be conflict of interest, Mr. Speaker. That's what I'm saying. When we talk about conflict of interest, sometimes it is unrealistic if we do not give it proper indicators. The MPs from the National Assembly, they issue bursaries, Mr. Speaker. These bursaries, they go through the NGDF, the CDF, NGCDF, Mr. Speaker. They do that at the expense, probably just they are the MPs, they are the one who are issuing these bursaries, and they are still benefiting from that politically. Mr. Speaker, wouldn't you call that conflict of interest? When it comes to an MP issuing bursary to the people, and he's only doing that within the period that he is an MP, and that means somebody in that ward or that constituency who would want to vie for that seat will be somehow disadvantaged in the future because this MP is issuing bursaries, yet you are not giving anything at that particular time, Mr. Speaker. So I think the bill should be clearer, which I'll be moving some amendment, Mr. Speaker. And if you look at section, I think it is 31A, if I can get there. Section 31A, and if I could read, this section determines what body is responsible, the responsible commission for a public officer for the purposes of this act. So the commission that will be mandated to oversight certain entities, agents, other government officers, and government officials. It goes ahead, 31A2, to say, the Committee of the National Assembly, that is a committee of MPs, responsible for the ethics of members, is the responsible commission for, 1, the Cabinet, member of the National Assembly themselves, the Director of Public Prosecution, the Secretary to the Cabinet, members of the Judicial Service Commission, members of commission and independent offices specified under Chapter 15 of the Constitution, members of the Ethics and Anti-Corruption Commission, and staff of the Commission holding the rank of Deputy Director and above. I have no problem with that, Mr. Speaker. But if you read that 1A3, the Committee of the Senate, now this is the House, Mr. Speaker, responsible for the ethics of members is the responsible commission for senators. Mr. Speaker, if you read that a whole Senate has only been reduced to just oversight themselves. A whole Senate that is mandated to oversight the cabinet secretaries. That's why they appear before the committees of the House. We cannot ask them when it comes to matters conflict of interest. And you know that is where everything begins, Mr. Speaker. I think I will be bringing an amendment, Mr. Speaker. Instead of saying the Committee of the National Assembly, will be saying the Committee of Parliament. So that either House, that is the National Assembly, and the Senate can be, the committee can check on matters conflict of interest to the Cabinet, members of Parliament, and each House will take care of their members, the Director of Public Prosecution, the Secretary to the Cabinet, the members of Judicial Service Commission, members of Commission in the independent offices, and also members of Ethics and Anti-Corruption. Can you imagine, Mr. Speaker, that this House was only mandated to check themselves? I think this is a clause that would call this whole Senate to, first of all, pause everything that we are doing and discuss this issue, Mr. Speaker. Mr. Speaker, the other day, the EACC gave a report, and the report they issued was on the bribery index. And they mentioned some of the counties that bribe as much money. And they talked about Nyamira County, which on average, somebody is bribing at 163,000 to get employment. And yet you see on the floor of this House, somebody said that they gave 800,000 to get an opportunity to work for the county of Kisii. And that person was also from Nyamira, Mr. Speaker. What I'm trying to say is that if these bodies that we are giving this mandate, they can give us statistics, they can tell us this county people are bribing, yet they are not doing anything. They're just acting, and I'm talking about EACC, Mr. Speaker, as just an opinion poll, a kind of commission that will just come and tell us this county, the people are known to be bribing, yet they have not arrested anybody, they have not taken anybody to court, they have not even issued warnings if the law permits that, Mr. Speaker. Yet, as a Senate, we are told that we should not call them and ask them questions, Mr. Speaker. Mr. Speaker, NTSA was among the government bodies that are accepting huge amount of bribes. They were number one. Number two was judiciary. And number three were county governments. Mr. Speaker, county government are not in section 31A3. That the Senate, we are taking away our mandate to check the county governments when it comes to conflict of interest. And who are they giving this mandate? The Committee of the County Assembly, responsible for the ethics of members, is the responsible commission for county executive committee members. Those are the CEC, MCAs themselves, and members of the secretary of its respective county public service board. No one has been given an opportunity to oversight governors. Governors are free to do whatever they want to do if this bill was to pass the way it is, Mr. Speaker. They have not been mentioned anywhere, even when it comes to the members of the committee, members of the county assemblies, Mr. Speaker. So I think once we get to the third reading, we'll be bringing such amendment, because actually the governors, they are the one who are exercising conflict of interest more than anybody, Mr. Speaker, because they're the CEO. And if you read the law in this country, no one is a CEO of a certain government other than governors. The president is not even a CEO of the country, but the governors are. They are the one who, through their committees or CCs, execute mandates, implement budgetary provisions and allocations are directed, Mr. Speaker. So I think on the issue of governance, it should be here as a section by itself. The governors are the ones who are not paying pending bills. The governors are the ones who are convincing MCAs to pass budgetary allocations or budgets that are unrealistic so that they can commit county monies even without having it, Mr. Speaker. The other day, and I'm really happy that the president of this republic, President William Ruto, convened a sitting with all heads of parastatals and CEOs. And he told them, Mr. Speaker, you should not execute a budget or commit a budget of monies that you don't have, Mr. Speaker. If you don't have that amount, don't commit it. That is the way to go to fight pending bills. And this is what we need to do to the governors also, Mr. Speaker, because they are committing money. And once they commit, once they know they are going home, like in the case of Kiambu, Mr. Speaker, we have had 4 governors, Mr. Speaker. Once somebody realizes I cannot be re-elected, they commit monies to entities in the name of collecting bribes from contractors. The moment they commit money, they issue contracts, they get their bribes, then they are not voted for, they go home, then they leave the contractor asking for the next governor to pay their pending bills. The next governor will never pay. Because one, you did not have proper papers, probably you did not execute, probably you did not support that governor, Mr. Speaker. And this issue of pending bill will only end, Mr. Speaker, once we curtail, once we stop the governors from over-projecting a certain percentage of their revenues or of their own source revenue, Mr. Speaker. And that is to say, I have an amendment of PFM Act, Mr. Speaker, that will be coming to this House, and I'm asking and requesting the members of the Senate to support when it comes before the counties pass their budget, that you cannot over-project your own source revenue for the next financial year more than 20% of what you collected in the previous audited year, Mr. Speaker. Because if you do that, Mr. Speaker, you will only spend what you don't have. And if you spend what you don't have, you will never, ever cure the issue of pending bill. And as I conclude, for you to get clarity on what I mean by this, Kiambu County has projected to collect 8 billion, Mr. Speaker, because it's 7.9 billion, 8 billion. And so far, they have only collected 1.6 billion, half within the year, the financial year. So meaning the next half of the financial year, they're going to collect another 1.6 billion. That will be 3.2 billion. If you minus 8 billion, 3.2 billion, that is a county that has gone short almost 5 billion. Yet they have committed that amount. And they have given contractors work worth 5 billion. They have pending bills of 5.7 billion. So by the end of this year, I'm telling you, Mr. Speaker, the county government of Kiambu will have pending bills of 10 billion. For us to cure this, we have to support such kind of laws. We have to come up with such amendments. And as I support this conflict of interest bill, Mr. Speaker, agree and allow me when we get there to bring some amendments. Thank you very much, Mr. Speaker.
Thank you, Senator Karungu. Senator Crystal Asiga.
Thank you, Speaker, for the opportunity to contribute to this bill. Speaker, I'm not sure if a bill will really solve the deeply entrenched problem of corruption in our country. I would have hoped that that would be something that will be left to our population, to look into our morals, to look into our values as people, as a society. Speaker, the need for bringing a bill to try and curb corruption and conflict of interest and all of the other issues that ensue, Speaker, for me, may not really go into solving the true problem that Kenya faces as a country. Mr. Speaker, I want to highlight a few data sets from the EACC National Survey, just so that Kenyans can understand what types of issues that we're really dealing with. Mr. Speaker, the study surveyed about 5,100 households across the country who are above 18 years of age. It says that 53.7% consider that corruption is high in the country. Ministries most prone to corruption, Mr. Speaker. The Ministry of Interior was first, 47.1%. The Ministry of Health, 13.2%. The Ministry of Transport is at 5.8%. Government departments and agencies most prone is the next one I want to highlight, Speaker. Police, 60.6%. That is of national share of bribes, Speaker. Next is immigration at 4.4%. Registrar of Persons, 4.0%. NTSA is next, and after that is TSC. Speaker, county services most prone to bribery, according to this report. County Health Service, 39.1%. County Transport, 11.9%. Trade Development, 10%. County Commissioner's Office. Next, County Public Service Boards. Next I highlight the counties that are most prone to bribery, according to this report. Nyamira is first, Speaker. Next is Baringo, Siaya, Bungoma, Turkana, and it goes on and on, Mr. Speaker. The average size of bribe, according to this report, went from 6,865 in 2022 to about 11,625 in 2023 alone, almost double in a year, Mr. Speaker. Job seekers were at the top, giving about 160,260 shillings as a bribe to look for jobs. People looking for passports, people pay about 4,000 shillings. People seeking police abstracts, they pay about 20,300. Obtaining a tender, people pay about 17,000 to obtain a tender, according to the report. Solving land conflicts, Mr. Speaker, an average of 12,673. Mr. Speaker, I also want to move into another piece of data that was interesting to me. The top 5 forms of corruption nationally. Bribery, 41.0%, as we're talking about. Mr. Speaker, what I've concluded is this, that we really need to find a long-lasting and sustainable solution to corruption. If we talk about a bill, and we all know that a huge problem in our country and several other jurisdictions is implementations of legislation. Legislation can be good, it can be well-meaning. The spirit of different provisions and clauses to curb particular issues can be very good and written very well. However, the implementation part is always the problem. And therefore, if we see such high and such exorbitant data sets with regards to corruption and bribery in the country, how can we really say that this piece of legislation will solve our problem holistically? Mr. Speaker, Clause 23(3) of the bill introduces stringent restrictions on public officers, requiring prior approval from both reporting authority and ethics and the EACC before engaging in additional employment. This bill casts a wide net in its definition of public officer, Mr. Speaker, encompassing individuals serving the government in various capacities, whether appointed or elected, on a full-time or a part-time basis, and regardless of their permanency, Mr. Speaker. This expansive definition to me extends to include state officers, employees, consultants, volunteers as well, and even medical professionals, Mr. Speaker. However, Speaker, this provision raises concern for me It fails to acknowledge the numerous opportunities that public officers create through their supplementary employment ventures. Many public officers, as you know, particularly medical professionals, often face financial challenges, such as irregular salaries, as we're seeing with KMPDU, and must support their family in some way. Imposing restrictions on their ability to seek additional sources of income may exacerbate their financial hardships, Speaker. Furthermore, Speaker, the proposal overlooks the temporary nature of certain public office tenures. For example, members of Parliament may serve for only a limited term, such as 5 years, which is the minimum. Is it fair to prevent them from pursuing additional employment opportunities during their tenure, Mr. Speaker, effectively pausing our growth in different income streams across the term that we are serving? Mr. Speaker, that is a question that hasn't really been fulfilled for me through this bill. As we know, many members of Parliament, many public officers, from the top all the way down to the bottom, we all talk about having a side hustle. And so, Mr. Speaker, that is something that perhaps needs to be looked into in this bill. While it's crucial to uphold integrity, Speaker, and prevent, of course, conflict of interest, any measure should take into account the diverse circumstance and needs of public officers. Simply restricting them to earn a livelihood could have widespread repercussions, in my view, and it jeopardizes both their financial stability and their capacity to serve the public effectively, and maybe even pay long-standing debt. The bill further stipulates that each public officer must submit a declaration of income, which is good, also assets and liabilities for themselves, their spouse and or spouses, and any dependent children under 18. Mr. Speaker, for this, the provision, it contradicts Article 31 of the Constitution, which guarantees the right to privacy, Mr. Speaker. Article 31 states that every person has the right to privacy, which includes protection against unwarranted intrusions such as searches, seizures, and necessary disclosure of family or private information, or infringement on the privacy of communications. Mr. Speaker, how does this bill set to reconcile this issue? It's evident from this constitutional provision, Speaker, that no one should have access to information concerning the family or private affairs of a public officer like myself. While it may be reasonable to require some level of declaration, of course, who willingly accept their positions, this should not, to me, extend to family members, spouses, children who didn't choose this public life. Mr. Speaker, there are many other issues that I cited in this bill. However, because of time, I want to just conclude by saying corruption is not going to be curbed by provisions, verbiage, legal language on a piece of paper. We really need to go into the heart, which is morals, which is how are we bringing up our children? What kind of discussions are we having in our households? What kind of talk and lessons are we imparting to our children on the dinner table? How are we treating family affairs? Mr. Speaker, there are many other things that I feel need to probably come before, that will have to precede this kind of bill and what it's trying to achieve, Mr. Speaker, and that does not lie in a piece of paper. I think that we may be at the risk of just doing this cosmetically, just to say that we have a bill and it says 1, 2, 3, but we're not really solving the problem at hand and not doing it in a long-lasting and sustainable way. Mr. Speaker, we really need a revolution in Kenya if we are to curb corruption. In fact, in Africa as a whole, but because we're talking about Kenya and that's the country that we're all here to serve, I feel that a revolution is the only thing that will really get rid of corruption in our country. I thank you.
Thank you, Senator Crystal. Senator Olekina Ledama.
Thank you, Mr. Speaker. Mr. Speaker, sir, this is a bill that requires people to wear their spectacles to be able to really understand what is the clear objective of this bill. Mr. Speaker, this is a bill that, if I were to be asked, is a bill which no member should stand here and support or oppose it before they get an opportunity to read the report on the Committee of Legal Justice. Mr. Speaker, I've attempted to understand the gist of this bill, and to me it sounds like one of those bills which are imposed to this country by the World Bank. One of the biggest challenges that I have in absorbing the content of this bill is because most of it, Mr. Speaker, is utopian. If you ask me, what is the object of this bill? It clearly says it's to the management of conflict of interest in discharging of official duties. The first question that, Mr. Speaker, I ask is that what are official duties? It also talks about administration. Mr. Speaker, if you look at this bill repeals sections of other existing legislations, which I dare say play a critical role in governance in this country. Bills that, Mr. Speaker, were drafted after the promulgation of the Constitution. Some of the bills, the consequential amendments, which are listed in the third schedule, Mr. Speaker, includes repeals of sections of the Anti-Corruption and Economic Crimes Act, number 3 of 2003. Mr. Speaker, it also talks about repeal amendment of Section 1 of the Ethics and Anti-Corruption Commission Act, number 22 of 2011. And then the other sections of another legislation that it repeals is the Leadership and Integrity Act, number 19 of 2012. If you look at Section 2, is deleted. Section 6.3 is deleted. Section 6.4 is deleted. Section 13.1a is deleted and substituted thereof with a new paragraph. Section 14, 15, 16, 17, 18, 23, 26, 27, 28 are all deleted. Section 52 is also deleted. And if you read further, Mr. Speaker, you will understand that this is really not a bill that has been thought out clearly and legislators given an opportunity to really understand what this bill hopes to achieve. Mr. Speaker, I've looked at what this bill is really trying to deal with, and I can narrow it down to about 4 issues. Issue number 1 is the issue of disclosures, which is required for every public officer. You know, the same forms that we fill, although I've looked at the bill, and it extends a little bit further because it requires now feedback from the reporting agencies. It also talks about the recusal. In the event that there is a conflict of interest, you have to recuse yourself. But even that in itself, Mr. Speaker, has not been fully thought out because there are certain sectors of this public office entity that have been left out. It tries to focus on issues of transparency, Mr. Speaker. It is actually trying to cultivate a culture of transparency. Mr. Speaker, the next thing that this bill talks about is the issue of penalties, like what happens. I'm really trying to demystify the gist of the entire bill because it talks about certain penalties, and whereas there are penalties that have not been spelled out, it says if you're a person, you will be charged 4 million shillings, and the other will be charged 10 million shillings if it's an entity. 4 million shillings with 10 years imprisonment. Mr. Speaker, we have a tendency in this House of really fast-tracking National Assembly legislations. When they are brought, we put them through the conveyor belt so fast, and most of us don't even understand them. while our own bills originated from this house, they are collecting dust at the National Assembly. In fact, if you read this bill, Mr. Speaker, you'll get to a point where the National Assembly is given so much powers as a reporting agency. I'll try and look at certain provisions of this bill, which I think the drafters of this bill have thought about, but not really. But they need to expand it. And I really do hope that this time around, distinguished senators can get an opportunity to really internalize this bill. We don't want to be counted as those people who go in and clap for a bill and they don't even know what it is about. They haven't read, so that tomorrow when it is affecting us, we start complaining. Mr. Speaker, when you are told that when you're a public figure or a state officer, that you've got to disclose all your money that you earn, the money that your wife earns, the money that your children earn, the money, I mean, seriously, what sort of draconian laws are these, Mr. Speaker? You'll find families that the husband and the wife, they don't talk to each other. They just live in an arrangement. They collect, they make their own money. But now, if you are a state officer, you are now asked, Mr. Speaker, imagine this, that wife of yours that you don't talk to, that child of yours that you don't talk to, who has her life or his life, for you as a state officer, you must disclose how much money they earn. You must disclose all their income. I mean, seriously? Just because we want to please the World Bank, we just really come up with legislation that don't help us? I long for the time, Mr. Speaker, when we as a country can be able to develop our legislation taking into consideration our culture, how people struggle to be there. You know, if you read the people who are tasked with the administration of this conflict of interest legislation, number 5, we say the act shall be administered by reporting authorities, and I'll define who those reporting authorities are, and the Ethics and Anti-Corruption Commission. Mr. Speaker, why should we not just look at the EACC Act, go through it together, see what we can change, because no law is static. Things change. We're very good as a country, Mr. Speaker, in drafting legislation. We are very good. We pass them, but they're only good on paper. There's one section which is very utopian in its nature. It says, still on the number 6, the function of the commission under this act shall be 6B, develop an effective system of reporting violations of this act. So the EACC goes out and develop a reporting mechanism. And then below in number 7, it says the commission shall in performance of its function under this act have the powers to, number 1, conduct investigation on its own initiative or on a complaint made by a member of the public. I wish it went further and say that what are the requirements? Once you complain, how are you sort of like putting the no on the entire investigating mechanism? When is it reported back to you? Because you made a complaint. You are a consumer of this bill. You've complained to the commission. How does the commission write back to you? We need, because I know this is going to pass, we need to be able to expand that section and amend that section, Mr. Speaker. There's a provision which I think is very dangerous, and all of us must really pay attention to it. Still, number 7, it says, delegate to another person or body by notice in the Gazette any of its powers or functions under this act in respect to classes of public officers specified by the Commission, and that persons of the body shall be deemed to be responsible for the administration and management of conflict of interest. Mr. Speaker, that's a very, very dangerous clause. We're already seeing what is panning out there. If you read Article 156 of the Constitution of Kenya, where it gives the powers to protect public interest to the Attorney General. And then the same, when you go to the Attorney General's Act, you will see that he is now given the powers to delegate. And in most cases, he will delegate to the Solicitor General. Mr. Speaker, a very mischievous government will then bypass the Attorney General and goes to the Solicitor General, because the Act gives that person the power to delegate. Who is this person who the Commission shall delegate their powers to? If we've set up a commission which is set up under an Act of Parliament, why then not either amend that Act of Parliament or do away? Mr. Speaker, I would propose that this very dangerous clause should be deleted, so that the independence of a body and everybody out there will not be confused on the powers of that commission. Allow that commission to perform its function, but not restrictively, but not now create room for it to be abused by setting up another agency that is delegated powers. Because, hypothetically, Mr. Speaker, if the powers that be are not happy with the independence of the commission, then they will just go to the other person who is delegated. It creates room for corruption, which is what we are trying to deal with here, Mr. Speaker. Mr. Speaker, if you read 7, the Commission shall, in performance of its function under this Act, have the powers to, D says, cooperate and collaborate with any public entity or agencies, any foreign government, an international or regional organization in the management of conflict of interest and, I proceed, enforcement of this Act. Mr. Speaker, what is it that we do in this House? We've got 2, and hopefully soon we'll get a third committee on oversight. We've got the Public Accounts Committee. We've got the PIC Committee, Public Investments Accounts Committee. I would have hoped that now that you're trying to really deal with the issue of corruption, incorporate the aspect of these 2 committees to be able to work there. So leaving out the Senate, yet sometimes we have these ESCC people there sitting with us in our committees. Why then not say in this aspect that even the Senate, so that you can deal with the corruption in the counties, Mr. Speaker? You know, and later on, I hope we'll have time, I don't know if we'll have time, that I'll be moving my motion on pending of bills. But if you really want to deal with the matter decisively, then you've got to create room for this oversight house to be able to work directly with the Commission to punish these governors, to punish these people who are stealing all this money that belongs to the public. In my view, Mr. Speaker, I hold the view that this is not an act that has been thought out clearly. It is an act, it is a bill which is being rushed to be able to please other agencies like the World Bank. Mr. Speaker, if you read Section 13, which I don't know whether it's the one that you're saying we're going to amend, it says that a public officer shall not directly or indirectly use or allow any person under the office authority to use any information that is obtained in the course of performing official duties and is not available to the public to improperly further or seek a further. You had actually, I was looking at it and I said, they should limit it to strictly private and personal interest. You know, when I was born, and Mr. Speaker, you'll allow me to use a phrase in Masais. When I was coming out of the womb of my mother said, "Mbongalda, you know, my bongalalai. Hold your life, and I hold mine." Mr. Speaker, we should never be penalized.
You should, Senator Olekina.
I paraphrased it, Mr. Speaker.
You should qualify that to say you were told, because you could not.
I did. It's a, let me tell you, you know, some of these things we grow up knowing.
And it's a good one, though. I'm
And
saying
it says,
you should have qualified that to say, I was told that this is what my mother
yes.
said.
Oh, I like what you just said. Mr. Speaker, I wish I had more time. How many minutes do I have? 5 minutes. I hope that 5 minutes will drag. And maybe, Mr. Speaker, you can give me some additional time. Because this is something that I really, really believe that we need to be very diligent. We need to take our time. So what I was saying is that on that section 13, it is imperative that it is limited to an individual. You know, my brother has got no business dealing with my issues. Number 19, Mr. Speaker, a public officer shall not be a party to or beneficial of a contract for the supply of goods, works, or services with his or her reporting entity. Mr. Speaker, I think it is wrong to deny Kenyans an opportunity to be able to perform certain functions. If, Mr. Speaker, hypothetically, Mr. Speaker, you own a company that trades with the Senate, and that company has been trading with the Senate, it doesn't say that Wakili Sigei, Senator of Bomet, is trading with that. Mr. Speaker, I just want us to really put this thing into perspective. It should only be limited to an individual. If it is coming under your name, by all means, I agree you shouldn't benefit. But if it is your company, so this issue of indirectly, Mr. Speaker, that ought to be removed. And I can dare say, Mr. Speaker, if you go to these developed countries, you will not find such draconian laws. They are so quick to impose them on us, but they don't have them. Mr. Speaker, I'm a firm believer that Section 27 ought to be deleted completely in its entirety. I know the committee was probably recommending for it to be amended, but in my own reading of this bill, where it says, a former public officer shall not, and I'll read A, B, C, and D briefly, act for or on behalf of any person in connection with any specific proceeding, transaction, negotiation, or case in which the state is a party and with respect to which the former public officer had acted for or provided advice to the state. Mr. Speaker, the word former means I no longer benefit from it. In fact, if we are clever enough, Mr. Speaker, former staff have got historical memory. In fact, they will better advise someone because they can easily save the public money. In other jurisdictions, Mr. Speaker, former officers set up offices to offer consultancy services. In the United States, Mr. Speaker, former IRS officers who are working with the Internal Revenue Service set up consultancy services, and they will tell you, I was a former officer of the Internal Revenue Service. They help you be able to save your time. They help you negotiate better. Mr. Speaker, this Section 27, I believe, has to be deleted. Section 28, Mr. Speaker, is such other provision that I believe ought to be deleted, where it says a former public official shall not, during the period of 2 years. Why are you incarcerating me? Why are you making it difficult for me to make a life? Suppose that is the only training that I've had. So for 2 years, I'll stay hungry just because I happen to have been working in that department? Mr. Speaker, this is draconian and it has to be removed. Mr. Speaker, because of time, I will set other provisions which I think are very problematic. Section 31, every public officer shall submit to the responsible commission a declaration of his or her income, assets, and liability, and the income, assets, and liability of his or her spouse and dependent children. That is ridiculous. Dependent children. Yes, they depend on me. But the fact that they are dependent means they don't own anything. And if I'm paying for them their college, and maybe they go to college and get a job as a waiter, Now I have to follow my child and say, I need to know how much money you are making as a waiter because there's this ridiculous draconian law that we passed that requires me as a public officer to declare how much you are being paid as a waiter. That is ridiculous. Mr. Speaker, I want to request 2 more minutes. I conclude this matter. Mr. Speaker, if you look at 31A, where...
You have 2 more minutes.
2 more minutes. Thank you, Mr. Speaker. Where the National Assembly is given so much powers. You know, it says that the Committee of the National Assembly responsible for the ethics of members is responsible commission for the Cabinet, members of the National Assembly, the DPP, the Secretary to the Cabinet. Mr. Speaker, I propose that that section be amended to state as Parliament, which is both houses of Parliament. It is important, and I'm happy that we have our powers and privileges committees that deals with the ethics of our committees. But I think even in terms of the National Assembly, it ought to be reduced to that on its own. Mr. Speaker, is another very dangerous provision, which is 32(3). A public officer shall within 30 days after ceasing to be a public officer submit a final declaration relating to his financial affairs as of the date he ceased to be a public officer. Mr. Speaker, we have members of parliament who spend a lot of money and running for re-election. At the time when they were running, they had so much money, but they lose, unfortunately. So you want to embarrass that person that after 30 days, he comes in and tells you, I'm now bankrupt? Come on, where is level of respect and privacy to these things? You know he's no longer in office. I still also believe that Section 34, Mr. Speaker, has also got to be repealed. I invite members of the Senate to go read through that. The other one, which, Mr. Speaker, is very dangerous, is 39. If you read 39(2)(a), Mr. Speaker, it says, a reporting authority and the commission shall not conduct concurrent investigation over the same complaint. Mr. Speaker, we are 2 distinct houses. There is take it to public participation, just like the way the National Assembly does, is because we are 2 independent institutions that gives different opinions. That means now, if the Energy Committee of the National Assembly is seized of a matter of high, bills, electric bill, it means that the Senate Energy Committee will not be investigating that matter. That is an issue that needs to be taken off. Mr. Speaker, I really wish we had so much time, but I want to end by saying the following. Yes, we may want to appear as if we are compliant to the terms of what I call modern structural adjustment policies. But I think we have to look at our situation. We need to look at our situation. Mr. Speaker, I will instruct my office to draft amendments, to submit those amendments, whether they pass or not. The time when this bill will be punitive, when it will be hurting people, is when people will say, I wish I knew and I wish I listened. Mr. Speaker, I wish I had more time, but I don't. But I want to send this message that let us look at our situation here. Let us create legislation that fits our interest, but not the interest of Bretton Woods institutions. Mr. Speaker, I reserve my comment on whether I support or do not support, but I think my submissions really leads to one conclusion. Thank you, Mr. Speaker.
Nilikongwa na kali ya Kwema Sako.
Alikuwa anataka saa kuwa kama lawyer wako.
Exactly. Now you are coming. Kwanza pokea rambirambi zangu.
Amekufa kwani?
Unajua hata bila natembea huyu haishi kaa zaidi ya mwaka.
Wewe. Good play. Yes. He told me that he has a play. So nilikuwa nakuja kuona ndugu yangu akifanya play.
Kwa hiyo ni ukora ambayo mmezoea.
Tumezoea sana hii tunafanyanga. Mimi nauliza who is who?
Wewe una deal na nani?
Mimi hata sijui.
We asked the children, how many of you brushed this morning? And this little boy, his hand didn't go up. And I said, well, why didn't you brush this morning? He said, my brother was using the toothbrush. If I'd waited for him, I would have been late for school. I'm sorry, I get a bit emotional when it comes to that. To be able to change a child's life, to be able to bring back that confidence about their smile, for me, is phenomenal.
Kenya Revenue Authority, KRA, reminds all business operators, including those who are not registered for VAT, to electrically generate and transmit their invoices through e-Teams. Log on to www.ecitizen.kra.go.ke to register today and start your invoice transactions before 31st March 2024. Kenyans are also encouraged to request for an electronically generated receipt with every purchase. Together, let's ensure transparency and accountability for a great future. Don't